Hello, this is Matt on the Moon Lambeau channel. Attorney John Deaton, who is the attorney that is seeking to intervene in the SEC versus Ripple case on behalf of over 17,000 XRP holders, says that it's likely that Jed McCaleb, who is a co-founder of Ripple, though he's no longer with the company, he went on to found Stellar, the cryptocurrency Stellar Lumens. John Deaton says it's likely that Jed McCaleb actually worked out a deal with the SEC. We're talking immunity, effectively. So I want to share those thoughts with you, but before we go any further, I do want to be clear that I don't have a legal or financial background of any kind. I am not offering legal or financial advice, and you definitely should not buy or sell anything because of anything I say or write. I'm just an enthusiast who enjoys making YouTube videos as a fun hobby about Ripple and XRP and crypto in general, but that's all that's going on here. And so there was a tweet from BondCrypt XRP, which John Deaton shared, and it was to this story. This is a different link, but it's the same story. This one's from the Daily Hodl. It's titled, Crypto Platform Stellar Looking to Acquire Payments Giant MoneyGram. Now, I already covered that story, but I do want to make sure we got the table set, so I'm not going to go into tremendous detail on this, but you do need to be aware of this. This is what John Deaton was actually retweeting, this story. And so here you go. The Stellar Development Foundation reportedly wants to acquire payments giant MoneyGram. Citing people familiar with the matter, Bloomberg reports that the non-profit organization behind the blockchain payment platform Stellar Lumens, or XLM for short, is working with Boston-based private equity firm Advent International on the potential acquisition. The two firms have already contacted MoneyGram, but a decision has not yet been made. And so there you go. It was just interesting to note that Ripple was previously partnered with MoneyGram. That partnership was dissolved, and it was agreeable between Ripple and MoneyGram that it made sense to dissolve it. But it happened because the SEC went after Ripple, and there were just too many hurdles as a result, and you couldn't actually utilize XRP at that point due to the legal consequences. And so that ruined that. And now you see Stellar Foundation coming in with Advent, like, yeah, we want to buy that now. Okay, isn't that something? And so you're just sitting there thinking, like, okay, so is he going to get away? Are they going to get away with this? Like, in terms of, and I mean, to be clear, I still blame the SEC, but will it end up being the case that, there's some sort of legal clarity and then Stellar Lumens gets to have some sort of partnership and maybe they develop a product and bring it to market, something kind of like on-demand liquidity? Or will they ultimately be litigated also? I don't know. But either way, it seems to have created an opening that otherwise wouldn't be there. And so here you have the SEC effectively choosing winners and losers within the marketplace, which I detest. And so John Deaton shared that story, and he tweeted out the following. In 2018, Ripple acquired a 9% stake in MoneyGram. The SEC allowed this purchase, knowing that XRP would be distributed to MoneyGram, and that MoneyGram would not hold the XRP. Well, he wrote HODL, same thing. But sell it in the secondary market on exchanges to individual investors. Which, by the way, to me, that was one of the most ridiculous things. The SEC, they approved this purchase knowing that XRP was going to make it to more investors, which they say are harmed by this, yet they approved it. What the hell kind of backwards world do we live in? And then John Deaton writes, 2 years later, the SEC sues Ripple and claims that all XRP, including XRP sold in the secondary market by MoneyGram on exchanges like Coinbase to individual investors, were always unregistered securities. The SEC claims it filed the suit to protect individual investors from buying XRP. Oh no, I feel so protected. I feel so protected now. What I want to know is, why didn't they protect me sooner? Because look, I mean, I jumped in November 2017. That's when I bought XRP. Why didn't they protect me so much that I couldn't have even purchased it? Why didn't they, just to say, why didn't they act sooner if they felt so strongly about this? Because they went after all these ICOs, but much greater damage, according to them, was done within the XRP ecosystem because of the evil villains Ripple and Brad Garlinghouse and Chris Larson. So why didn't they go after those people if they really believed that they were that nefarious? If they actually did? Well, because they weren't convinced that was the case. They figured out quicker. They decided it was easier to determine ICOs were not compliant with securities laws. They weren't so convinced that was the case with Ripple and XRP. That's pretty damn clear, or else you stop the tremendous damage that's going on. but they didn't. And so then John Deaton writes the following. Although the SEC claims that all XRP are unregistered securities and Brad Garlinghouse and Chris Larson unjustly enriched themselves, it allows Ripple co-founder Jed McCaleb to sell his XRP for hundreds of millions of dollars to possibly buy MoneyGram. Makes perfect sense. Now, look, as far as how the money's flowing, that is one thing where I will just say I'm not entirely sure that's the case, and I actually happen to have talked about that in my own video. It's this idea of, so are these riches that Jed McCaleb's getting from selling his XRP fortune, and it's a veritable fortune, absolutely, is that money actually going to make its way to the Stellar Foundation and result in the purchase of MoneyGram? Well, I need to see data for that. I mean, it's not technically impossible, but that would be just kind of like assuming that Brad Garlinghouse or Chris Larson, the XRP that they're selling, that's going to enrich them. There's no evidence that's flowing in to enrich Ripple, right? And so I don't see a reason right now. If there's evidence, then fine. Happy to acknowledge whatever is evidence. I'd just be kind of surprised. That's all I'm saying. But if that money did flow from Jed McCaleb to Stellar and then they bought MoneyGram, that would be something. And I would be happy to cover that if that ends up being the case. I'm a little skeptical on that. But either way, why does Jed McCaleb, why is he allowed to continue to sell his XRP when he's a co-founder of Ripple? Isn't that harming investors like me and you? Isn't it? Doesn't the SEC believe that? Because they're saying that Brad Garlinghouse and Chris Larson, with Brad Garlinghouse being Ripple CEO, Chris Larson also being a co-founder of Ripple, when they do it, it's bad, but when Jed McCaleb does it, not bad? Well, what the hell's going on there? And this is where it gets even more interesting. Check this out. There's an XRP community member named Massimo, if I'm saying that correctly, and I may or may not be, I'm doing my best. He said, responded to John, wrote, "What do you think about Jed being a whistleblower in exchange for immunity, John?" And John Deaton did respond, and he wrote, "It's likely. Jed stopped selling XRP for 2 weeks once the lawsuit was filed, but then began selling again. That's very curious. Plus, the SEC got its hands on the 2012 legal opinion letter from a law firm from somebody. Not many people would have access to that letter." And that's true, too. I mean, I thought it was curious because I reported, look, Jed McCaleb, when he stopped selling, I reported that on the channel. When he started selling, I reported that, too. And it was like, all we can do is speculate. And I thought maybe it's just the case that he feels like he's got sufficient clarity because, I don't know, he hasn't been with Ripple for so long, or maybe his attorneys think that it's fine. So it was either that or worked out something with the SEC. Like, was he specifically in touch with the SEC? That we're not privy to, but that is perfectly reasonable to speculate on. Absolutely it is. And so let me share with you the specifics because Massimo had another question. Which letter is that, by the way? Must have missed that. And John Deaton did share it, which it's on your screen now. In the complaint the SEC references these legal memos, which of course are protected by attorney-client privilege. Ripple would never turn these over absent a court order. Someone either gave these memos to the SEC or disclosed the contents of the memos at a minimum. And look, I've been curious about this for some time too. Here's the screen grab you share. But I've been wondering this for a long time. I'm like, how did this leak out? I mean, like, did somebody give it to somebody in good faith and just say, "Hey, this is private communication," and then it leaked out anyway? Somebody outside of it, like, was it intentionally given to a third party that then was just like, "I'll do what I want with this"? Or is it the case that perhaps Jed McCaleb worked something out previously? Was he speaking to the SEC prior to all of this? And I don't know. At some point, he got some sort of legal clarity, but like when the charges came down, I do believe this was in the initial complaint here. So, if Jed McCaleb is the one that handed this over, then it would have been prior to the actual legal complaint coming down. But either way, somehow this happened. And so this is page, looks like 10 of 79 of the legal complaint, SEC versus Ripple. And here you can see a little point number 54 here, which reads as follows. Both memos warned... and so they're referencing memos from Ripple's legal attorney. Both memos warned that XRP was unlikely to be considered currency under the Exchange Act because, unlike traditional currencies, XRP was not backed by a central government and was not legal tender. And by the way, that's kind of funny because XRP with that deal that came in with FinCEN in, I believe it was 2015, XRP did end up getting regulated as a currency. They said virtual currency, but it's regulated just like a currency, which was very fascinating. And they thought that added sufficient clarity there. And so it's just interesting to me there. So it's like, if you're going to take that word, it's like, how are you? Well, then if that's the case, it's like Ripple's lawyers were wrong there, because they said, hey, it could be declared this. But even then, like, wrong's too strong a word, because it's more like, here's something that the SEC could come and charge you with. It's possible they could charge you. It doesn't mean that their argument is a good argument, though. And so it's just one of those things. So I don't know. I don't know. But you got to sit here wondering, how the hell is it that Jed McCaleb is scot-free here, and then Brad and Chris are not? That does not make logical sense to me. So maybe there was some sort of deal worked out, even if it was after the fact, even if it's after the SEC came after Ripple. But if there isn't something worked out, then it must, I would think, simply just be the case that Jed McCaleb, after speaking with his attorneys and looking at all of the data that was available, decided that he probably wasn't at risk, and who knows what the rationale for that would be. But it's got to be one or the other. So I don't know. Either way, it's not right. This doesn't make a damn bit of sense. I don't see how Jed McCaleb gets away with this if Brad and Chris don't. It is not logical, clearly. But I'll go ahead and wrap up there. You guys let me know what you think on all of this. I think a little healthy speculation on this topic is perfectly fine here. I would love to get other perspective, because I'm not completely sure what is likely, but this seems completely plausible what John Deaton brought up here, for sure. So I'll wrap up there. I am not a financial advisor. You should not buy or sell anything because of anything that I say or write. That would be a very, very, very bad idea. Until next time, to the moon, Lambo.